Thank you, Mr. Chairman, members of the committee. My name is Brian Gould. I'm a lawyer here in Concord. I practice with Cleveland Waters and Bass, 2 streets over. I practiced law in New Hampshire about 35 years. Over the course of my career, I've regularly litigated constitutional matters, which is unusual because I'm a civil litigator, not a criminal litigator. They deal with constitutional issues frequently, but in the civil context, not quite as much. To give you a couple of quick examples, I was the lawyer for the governor and executive council when the legislature attempted to modify the statute that would dictate who the Chief Justice of the Supreme Court would be. And we prevailed on an original petition before replacement justices on the New Hampshire Supreme Court, because they were all recused because it affected all of them. But we prevailed in that case, and the reconstituted court, held that that the legislature had violated the separation of powers and had violated the Constitution by attempting to intervene in how the Chief Justice was selected. Another case in which I worked was more recently was the Senate Bill 3 litigation. I know the chairman is very familiar with that because I believe he delivered the committee report on the floor for the Election Law Committee supporting that bill. I was retained by the state of New Hampshire to supplement the defense of that bill by the Attorney General's office. I represented the Attorney General, who at that time was Gordon MacDonald, and the Secretary of State, who at that time was Bill Gardner, in that case. And we tried that case, and eventually it was taken up to the New Hampshire Supreme Court, and the bill was struck down. The reason I mention this is because over the years, I've developed a fair amount of experience with election law. I'm not at the level that, say, Bud Fitch is. Bud is sort of encyclopedic on those things over at the Secretary's office. But I have had a fair amount of dealing with these cases. Those of us, and I count myself among them, who favor increasing the integrity of our elections, have to face some facts, though, because these issues end up getting resolved in the courts. And so it's not a matter of theory, it's a matter of experience. What have we learned from the courts in New Hampshire over the years? One thing that we can say with some certainty is that the courts look very skeptically on changes in law that restrict ballot access from what it is currently. So you start at a disadvantage to the extent that you're trying to cut back on ballot access. And that is sort of an overarching principle here is, if you think about it, there's tension between the desire to ensure that only qualified voters can pull a ballot and the burden that's placed on voters, their right to vote. Because if you are going to restrict access, you're going to say, I'm going to impose these qualifications. You are necessarily excluding some voters as unqualified. And the question becomes, is that necessary to protect against unqualified voters voting? And that's the balancing that the courts undertake. Another observation is, and this is why I decided to come today, because it's not so much the underlying policy that's being promoted by this, but the vehicle by which this is being proposed. Because aside from the language of any amendment to the RSAs, probably in an election law case, probably the most important factor is whether the new restriction, the most important factor in determining whether the new restriction survives judicial scrutiny is legislative history. If any inflammatory or eccentric language in legislative statements, not that that would ever happen, but whether it's in the bill, in committee, on the floor, make the defense of the new language very difficult. As an example, in the Senate Bill 3 case, the plaintiffs, who were the Democratic Party and a national super PAC, had become involved and recruited some plaintiffs. But they focused on the fact that some people, even just lobbyists, had testified that the reason for this bill was to prevent college students from voting in New Hampshire elections. And the bill did nothing of the kind. But because that was in the legislative history and showed a certain hostility to a certain class of voter, the Superior Court seized on that as evidence that this bill was intended to restrict votes without an appropriate basis. And I know that House Resolution 25 doesn't actually amend anything, although it sounds like there's some debate about that. But if it were to pass and legislation were actually enacted, that is consistent with the objectives of House Resolution 25, the resolution itself will be part of that legislative record if the bill is challenged on in the courts. And I believe that several parts of this resolution will make future consistent amendments to the statutes, that is, regarding absentee ballots and voting machines, far more difficult for the Attorney General's office to defend. For example, you heard a reference to the Constitution as being a trust instrument. There is one reference to trust in Part 2, I think it's Article 84 of the Constitution, but the Constitution doesn't itself say that it is a trust instrument. So the reasoning that flows from that assertion in this resolution would be viewed, I think, as it's interesting intellectually, but I think the courts would view it as an eccentric point of view, which harms your ability to defend the legislation. This resolution relies on 16th century maxims of law from Lord Coke and Sir Francis Bacon, both of whom were controversial in their time. This was before the Pilgrims sailed for the New World, that they were positing these maxims under English law. I can honestly say I've never seen the New Hampshire Supreme Court cite one of these maxims. They may have at some point, but it's not likely to be very persuasive at all. And to include something that is that unusual in the legislative findings and recitations makes it very difficult to defend the merits of any change in the law that you might enact. Mr. Richard testified about his understanding of the Bruin decision, and I understand what he's trying to say about that. But I think what he's and the reason it's important is it's in the resolution. That's a very aggressive reading of Bruin, that it now eliminates the means ends testing. You may have heard of strict scrutiny, intermediate scrutiny, rational basis tests. These are all tests the courts use to determine whether a burden on a constitutional right is lawful. And the court did express skepticism about that in Bruin, but that case is limited to the Second Amendment. The court has not said that it's dispensing with that altogether. So for this legislature to accept that reading of Bruin before the Supreme Court has said that it applies across the board, and before the New Hampshire Supreme Court has said anything about whether it will follow Bruin for matters of state constitutional rights, again, undermines the legislature's credibility with the courts. And it's very important, if you're going to undertake these kind of policy changes in the election law context, that you have that level of credibility. There are citations to a number of authorities in this resolution, none of them to an opinion of the New Hampshire Supreme Court justices or an opinion of the New Hampshire Supreme Court itself. And in fact, that's important because during the Civil War, our court, the justices took up a statutory change to allow the men who were fighting for us in the Civil War to vote remotely. And our Supreme, which all of us I think would be generally sympathetic to, Supreme Court said no. The Constitution at that time did not allow for absentee balloting of this kind, and they didn't allow it. And there was a few years later, there was a fix that did get past the court. But my point is, there is New Hampshire authority, but that's not cited in this resolution, which is a red flag to a court that, you know, you're not even relying on established New Hampshire law as the basis for this resolution. And then finally, there's a reference in here to the people having what's called in personam jurisdiction over legislators. Again, a very eccentric way of putting the concept that the legislature is generally answerable to the people. To courts, in personam jurisdiction refers to the ability of the court to exercise authority over a party before it. So to use that term in this context is jarring. And so my point in all of this is, I'm not here to talk about, you know, whether voting machines are a good idea or a bad idea, or you know, the scope of absentee balloting, although I think the New Hampshire Supreme Court and the justices have made pretty clear what the law on that is. But it is critical, if you're going to go down this path, that whatever it is that you pass is credible with the courts, because that's where it's going to end up. And so if you care about the outcome, any of these references to obscure areas of law and this sort of theorizing should be very, very carefully vetted, because you don't want to pass something that the courts read and say, I don't even know what this means. None of this language makes sense to me. I can't relate to it. It's not something on which I would rely. So that's my testimony. Thank you very much for listening.
Thank you for your time. Appreciate it. Would you be willing to take a question or two?
Oh, sure.
Are there questions? I thought there might. Representative McCarter.
Thank you, Mr. Chair.
Good
Thanks
to
for
see you
coming
again.
You too. Thanks for coming today.
You bet.
I just have a quick question, and I would suspect you have the answer. Can you point me to where I can find in our Constitution where we have to wait as legislators, or the legislature as a whole, where we would have to wait for the courts to point out that we have created statute in error, or we have made a mistake and we need to fix that mistake? Can you define that for me? Because I'm having a hard time with that.
If that's the impression I left you with, then that's my error. I did not mean to imply that you have to wait for the courts. What I'm saying is that if you modify statutes, the predicate on which you modify those statutes will be relevant to a review by the courts of whether that change in law is lawful. The legislature has independent authority to determine whether a statute is unlawful or unconstitutional in the first place. It can certainly do that. But if the result of that determination is that you're going to restrict access to the ballot, that raises a significant issue in the minds of the courts. We have a lot of indications, most recently probably in the Senate Bill 3 decision, but based on the Guare decision, that the courts are going to look very carefully at a change in law that makes it harder to get a ballot. That doesn't mean it won't uphold it, but you have to understand you're going into those cases with the court being very skeptical. And that's the battle that I'm trying to point out to this committee is the one you need to think about winning, because you can pass anything, but the courts have the authority to declare what you pass unconstitutional. And to get past that, I think you need to build a sort of a better record than I think this resolution does. Hope that answers your question.
Can I just follow on that point a bit? Is it the fact of being a resolution that the court would question, or does that matter?
I don't think it matters. I mean, I'm not going to jump into the debate over whether a resolution is effective. I think Representative Pearson made the point that that it is a resolution and therefore is not binding law. I think that's my understanding of a resolution. I'm thinking longer term, because if the legislature wants to change these policies on voting machines and absentee ballots, it's going to have to enact legislation to change the law. This resolution, containing as it does a certain rationale for that, becomes evidence when that later bill is challenged, because it's part of, I've heard people say this resolution sort of sets the table for legislation. If that's true, then that means if there's a challenge to it, this resolution becomes part of the legislative record. And if there's something in the legislative record that makes the courts look askance at what the legislature was thinking, that makes it much more difficult to defend the lawfulness of that later legislation. So that the short answer is no. The fact that it's a resolution doesn't matter. It's the content.
Thank you. Representative Sellers.
Thank you, Mr. Chair. Thank you for taking my question. I'm trying to understand something you're saying there, that how does this resolution exclude voters or restrict the ballot access if it's requiring the government to follow the Constitution?
And I understand, and I'm very sympathetic personally to that. What I'm trying to get across is this. The challenge to laws that restrict access to the ballot are evaluated against what is the current state of the law. So even if you've gone beyond what the Constitution requires, and so you're passing a law that you think brings it back within constitutional boundaries, you're still restricting access to the ballot from what it was, right? That's the whole point. And what I'm trying to say is, when the legislature tries to restrict access, the courts look skeptically at that. It doesn't mean that the court won't uphold it, but the court looks skeptically at the legislature trying to restrict access. Because remember, I talked about there's a balance between the right to vote and this legislature's absolutely legitimate interest, which I defended at length and almost get to the point where I was out of breath in the Senate Bill 3 case. I'm very sympathetic to that. But those two things are in tension, and when push comes to shove, the courts tend to favor the access to the ballot piece. So I just want you to understand, what I'm suggesting is that the fact that you're trying to bring it back into balance with what the Constitution requires, that's a legitimate thing to do. But understand that when you're cutting back on sort of the liberality of access to the ballot, the courts are skeptical of that. And you have to take that into account in what you put in the record to justify that change.
Anyone else? Rep. McCarty.
Thank you, Mr. Chair. So are you suggesting that we need to be, as legislators, we need to be mindful of a perceived opposition from courts when we're looking to institute legislation or get statute through that would be 100% constitutionally afforded ballot access? Are you suggesting that because it might be viewed as whatever the term of the day is, voter disenfranchisement or restricting ballot access, that needs to be a consideration when we're putting forth election law type proposals, that we need to look at how a court's going to view this, not how the Constitution does? Are you saying that those need to be weighted evenly, one more than the other? Can you elaborate a little bit on that, please?
If you accept the proposition that there can be disagreement over whether a law is constitutional, I think we can all agree on that there can be disagreement. then you have to be concerned because the courts have the last word on constitutionality, at least under our current system. You have to be concerned that what you pass, as sincerely as you believe it's required by the Constitution, if a majority of the Supreme Court disagrees with you, then as a legal matter, you were wrong and the Constitution doesn't provide as you thought it did. And what I'm suggesting is this is a matter of wisdom. This is a matter of building the record so that whatever decision you make, and I honestly agree with you that absentee balloting got out of control in the during COVID and so forth. I think it needs to be dialed back. But what I'm saying is build a record that makes that decision defensible in the courts. It's not because it's my personal preference that you satisfy the courts. It's the recognition that the courts are going to determine if there's a lawsuit, whether that change is constitutional. So the smart thing to do is to build the legislative record so that that is a defensible decision. That's all I'm getting at.
Further questions? I have one. And I'll preface it by saying I didn't fully understand this. So the Bruin level of scrutiny mentioned under Bruin, it was said to me earlier in testimony, or it was said to us earlier in testimony, that because of Bruin, the other three methods or levels of scrutiny seem to be washed away by Bruin. Can you elaborate on, or do you concur? Do you disagree? I think I heard you say that Bruin was specific to Second Amendment.
It was.
But it sounded to me like the prior testimony was that it was now going to be something that the legislature had to take into account, this new level rather than the prior three levels.
Well, if it's a Second Amendment regulation, you would have to take it into account. What Bruin's, I've never liked the different levels of scrutiny, and Justice Thomas's opinion in Bruin really explained why. He said, at least in the Second Amendment context, what we're doing is yielding power to the courts to make policy decisions. If we allow the courts to say, is this an important policy and are the means that you chose necessary or rationally related to that purpose, you can see how that shifts a lot of power to the courts. And Thomas gave that idea the back of his hand in Bruin and said, at least in the Second Amendment context, what we're going to focus on is the right that's at issue, in this case, carrying a handgun in New York City. Is that right consistent with the Second Amendment when it was adopted? And the court said it was. Clearly, that people were allowed to carry their weapons in public. What the lower court did is it said, okay, now that we've determined that, we're going to determine whether this restriction is necessary to achieve this state policy. And the Supreme Court said, no, you're not going to do that. All you're going to do is look at whether that proposed restriction is consistent with the kinds of restrictions that were in place when the Second Amendment was adopted. And if it is inconsistent, then it's unconstitutional. So Bruin made Second Amendment law very simple. Bruin did not revoke this means ends test, strict scrutiny, intermediate scrutiny, and rational basis across the board. A lot of conservatives have sort of jumped on it and said, oh, this signals that the court's abandoning that. That's not the way lawyers look at things until the Supreme Court says, and by the way, we're doing away with all these means ends testing. We assume that it's still in place. More importantly, under the New Hampshire Constitution, Our Supreme Court uses means ends testing. So unless the issue is an issue of federal law, and this would be under the state constitution, which is being argued here, the means ends test is still in place in New Hampshire. There's nothing about Bruin that changes that for a question of state law. I don't know if I cleared it up or made it worse.
I'll have to get back to you on that.
I'm sorry.
I appreciate the answer, however. Are there any further questions? Rep. Sellers, yep.
Thank you, Mr. Chair. And I'll admit this stuff gets pretty deep, and I'm no expert on it, but questions come to mind and thoughts and stuff. And didn't in the New Hampshire Supreme Court, Worcester, I think Worcester versus Plymouth, call the people grantors, and therefore aren't they the ones that create trust? I mean, if it's already been stated that we're the grantors, and the grantors, we're the ones that create a trust, isn't that correct?
Well, to some extent, it's just a question of terminology, right? Because there's no question, but from the earliest articles in the Constitution, that the authority of the legislature comes from the people through their consent. So that's really indisputable. What I'm saying is that the Constitution does not refer to itself as a trust instrument. There is one reference in the oath section, which is Part 2, Article 84, to whether an officer, I think the language is, accepts the trust as a result of being elected. But to extrapolate from that to the entire Constitution as a trust instrument, understand that my point is not, is it in fact a trust instrument? My point is, how do the courts look at that? Do the courts look at that and say, that's a very eccentric view of the law. That's not the way we normally think about this. So just be aware that if you choose to go down that path, have a lawyer look at it and determine whether this is actually language that's consistent with the way the courts think about this stuff. Because if you don't do that, then when it lands on a judge's desk, the judge says, I've never understood this to be a trust.
Okay, I lied. It wasn't the last question. How?
Are my 5 minutes up?
Yeah, well, that was 5 minutes of testimony. The questions don't add
Oh, I
into
see.
the 5
Okay.
minutes. My question is, and I'm not going to lose the opportunity to ask, my question is how this could have been done differently, or could it have been done differently as requesting an opinion of the justices prior?
Yes.
Could you comment on that?
Yeah, and that's the mechanism, of course, under our Constitution for determining whether a statute proposed or existing, particularly in connection with legislation that would purport to change it, you could send it to the Supreme Court and say, give us an opinion, an advisory opinion, as to whether this law exceeds the authority granted to the legislature under the Constitution. That's the straightforward way of doing it, and you avoid all of the. I mean, it's a much quicker way of getting an answer, and you don't take the risk that you do with passing something that's as sort of arcane as this resolution. Run it through the Superior Court, then up to the Supreme Court. You have a quicker answer, and that is the way the Constitution contemplates that these kinds of issues would be presented to the court.
Thank you. I think that it does answer my question, but I have to think that through too. Anyone else? Yes. No, that's fine.
So, thank you again for
I'm just
coming.
glad I piqued your interest in it.
You have a lot of information in your noggin that I probably could afford to learn from. Are you saying that if we were to send for this House resolution to the New Hampshire Supreme Court and ask for an advisory opinion, that would be a prudent thing to do?
No,
Okay.
I'm saying I don't think
Thank you.
this resolution is a good idea. I think if you want to accomplish the underlying policy goals, that is restricting absentee balloting and restricting access to machines, you ought to maybe amend this somehow or put forward legislation that does that and ask the court whether existing law, whether this bill is consistent, the proposed bill is consistent with the Constitution, and whether existing law is consistent with the Constitution. That's what I'm saying.
See, that, I'm glad you asked that question. Thank you. I appreciate it. I think we appreciate your testimony.